This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And this is episode 7 of Constitutional Law. Today, we're tackling bills of attainder.
That's right. And just so you know, we are AI bots. We've been brought to life using AI magic and, crucially, Angela's brilliant constitutional law notes.
Yeah, Angela's the real brains here. She's a graduate of George Mason University, Antonin Scalia Law School.
Started out as a developer, which is pretty cool, then went to law school part-time and made the switch to a career in law.
And now she's an expert in legal AI and tech. Really knows her stuff.
Absolutely. Now, if you need to get in touch with Angela about the podcast, maybe questions or feedback, the email is podcast@studyforthebarinyourcar.com.
And she also does freelance law clerk work. So attorneys out there, if you need help with research, drafting motions, or even getting your office set up with legal AI.
You can reach her at hello@legalwriterandlawclerk.com.
Okay, enough housekeeping. Let's get into the main event, bills of attainder. It sounds, well, pretty old, doesn't it?
Yeah.
But it's still incredibly relevant for ConLaw.
Totally. So what is it fundamentally? A bill of attainder is basically when a legislature, Congress, or a state legislature passes a law that says this person or this specific group is guilty of a crime.
And then punishes them directly.
Exactly. Punishes them directly, all without any kind of actual trial in a court.
So the legislature is acting like the judge and jury.
And sometimes the executioner, historically speaking. Which brings us to the term attainder itself. In Old English common law, being attainted was serious business.
Like really serious.
Oh, yeah. It meant your civil rights were gone. Poof. Couldn't own property, couldn't pass anything down to your kids. Your property, often escheated, went back to the king.
Wow. Okay, so it was like being erased legally by the legislature.
Pretty much. And often it led to actual execution. That's the background.
Which explains why the framers were so dead set against allowing it in the U.S. Constitution.
Absolutely. This wasn't just some minor point for them. They saw it as a fundamental threat to liberty. They wanted to protect individuals and groups, especially vulnerable ones, from being declared guilty by politicians instead of courts.
And they made the ban absolute right. No exceptions.
That's the key. An exceptionless ban for both federal and state lawmakers. It was that important. They actually put this ban in place before they even finalized the Bill of Rights.
That really shows how high a priority it was.
It does. And as we talk through this, you'll see the connections to, well, big constitutional themes. Separation of powers, individual liberty, the rule of law. It all ties in.
So where did this practice really come from? You mentioned English common law.
Right, its roots are deep there. Parliament used these acts, bills of attainder, for centuries. It was often a tool for political or religious persecution.
Particularly during certain eras.
Yeah, especially the Tudor and Stuart periods. Think Henry VIII. He famously used bills of attainder back in 1542 to get rid of political opponents, execute them, seize their property, all without a regular trial.
Just Parliament passing a law saying, you're guilty, you lose everything, you might lose your head.
And that's the essence of it. Legislative punishment without trial.
And the American colonists saw this firsthand.
They did. They experienced similar things in the colonies, and even after independence, some state legislatures tried it. This wasn't just abstract history for the framers, it was recent lived experience.
Which explains their distrust of letting legislatures have that kind of power.
Exactly. That distrust is baked right into the Constitution.
Let's look at the text itself. Article 1, Section 9, Clause 3.
Right. That one applies to the federal government, to Congress. It says, clear as day, no bill of attainder or ex post facto law shall be passed.
Short and sweet. And they didn't stop there.
Nope. Article 1, Section 10, Clause 1 does the same thing for the states. It extends that prohibition, making sure states couldn't use bills of attainder either, creates uniformity.
Okay, so it's banned at both levels. Now, you mentioned it's still relevant. Let's talk about a more modern context involving Donald Trump. Angel's notes mention this.
Yes, this is an interesting and obviously politically sensitive area, but important constitutionally. The argument came up during his administration.
What was the argument?
Essentially, the administration argued that the Bill of Attainder clause in Article I only restricts Congress because Article 1 deals with legislative power. They argued it didn't apply to the president, whose powers come from Article 2.
That's a specific reading. Did this come up in relation to something concrete?
It did. Specifically, an executive order Mr. Trump issued targeting a law firm, Perkins Coie. The order was seen by some, including a federal judge, as potentially functioning like a bill of attainder.
So an executive order, not a legislative act. What happened?
Well, Judge Beryl Howell, who handled the case, she didn't buy the administration's argument. She pointed out that, the framers probably didn't foresee how executive orders could effectively have the force of law today.
Right, the landscape is different.
And crucially, she saw no good reason why the ban should only apply to Congress, looking at the specific language of the order against the law firm.
What did she say about that?
She said the language made it clear it was, quote, a means of retaliating against the firm, basically because they represented political opponents. She even said reading it sent little chills down my spine.
Wow. So the judge essentially found it functioned like a bill of attainder, even coming from the executive branch.
That was her take, yes. It really underscores that the principle preventing targeted punishment without trial matters, regardless of which branch is doing the targeting, especially when executive actions mimic legislative ones.
And this ties back to those structural principles we mentioned.
Absolutely. Separation of powers is key here. Deciding guilt and punishment adjudication. That's the judiciary's job. Not the legislature's, not the executive.
Bills of attainder completely break that separation.
They do, and they threaten individual rights by allowing arbitrary punishment. You're supposed to get your day in court, not be condemned by a law or an order.
So how does a court decide if a law is a bill of attainder? Is there a test?
There is. The Supreme Court laid out a three-pronged test, mostly from a really important case you need to know. United States v. Lovett from 1946.
Okay, love it. What are the three prongs?
First, the law has to inflict punishment. And the court interprets punishment pretty broadly here.
So not just jail time or fines.
Right. It can be things like banning people from jobs, cutting off government benefits, stripping privileges, things that hurt people in significant ways.
Got it. Prong one, punishment. What's second?
Second, there needs to be specification of the affected persons. The law has to target specific named individuals, or at least a group that's easy to identify, like all members of Organization X.
Not just a general law applying to everyone who does a certain thing.
Exactly. It has to single people out.
Okay. Punishment, specification. What's the third prong?
Third, and this is crucial, it has to be without a judicial trial. The law itself determines guilt or imposes the penalty. Legislative findings replace court proceedings.
That's the core violation of due process.
Right. Precisely. Bypassing the courts. So Lovett gives us that framework. Punishment, specification, lack of judicial trial.
And Lovett is the main case to remember for this framework.
Definitely. It's the cornerstone for analyzing bills of attainder. Other cases refine it, but Lovett sets the stage.
Now, Angela's notes also mention comparing this to related ideas, things that might seem similar but aren't quite the same, like ex post facto laws.
Right. They're often mentioned together in the Constitution, Article 1, Section 9 and 10, but they're different.
How so? Ex post facto means after the fact, right?
Yeah. An ex post facto law does one of a few things. It makes an act criminal after it was committed, when it was legal at the time, or it increases the punishment for a crime after it was committed, or changes the rules of evidence to make conviction easier retroactively.
Okay, so it's about applying laws backwards in time, specifically criminal laws.
Exactly. The materials point out they only apply to criminal or penal statutes, think Calder v. Bull. The key difference from bills of attainder is retroactivity versus targeting.
Ex post facto looks backward at conduct, while bills of attainder look sideways at specific people.
That's a good way to put it. Bills of attainder single out individuals or groups for punishment now, without a trial, regardless of whether the conduct was previously illegal. Ex post facto laws change the rules for past conduct for anyone who did it.
Got it. What about the Due Process Clause, 5th and 14th Amendments? That also protects against unfair government action.
It does, but it's much broader. Due process guarantees fair procedures generally and protects fundamental rights. It's a catch-all against arbitrary government action.
Whereas the Bill of Attainder Clause is hyper-specific.
Right. It targets that one specific abuse. Legislative punishment without trial. Due process is the safety net. The Bill of Attainder Clause is like a specific guardrail.
And both ultimately reinforce that separation of powers idea.
Absolutely. Bills of attainder let the legislature be prosecutor and judge, which completely undermines the courts. The ban protects judicial independence.
Are there modern situations where Bill of Attainder concerns pop up, besides the executive order example?
Yeah, concerns can arise. Think about legislative attempts to defund specific organizations or companies by name.
Like Congress passing a law saying no federal funds shall go to Organization Z.
Potentially, yes. If it meets the Lovett test specification, punishment, lack of judicial finding, it could be challenged. Also, in the national security context,
How so?
things like freezing assets of suspected terrorists, travel bans targeting specific groups, or detentions without trial. These actions, while often justified on security grounds, sometimes raise bill of attainder questions, or at least questions about due process and judicial review.
Makes sense. What about impeachment? That targets an individual.
Good question. But impeachment is different. It's a specific political process laid out in the Constitution for removing someone from office.
Right. House impeaches, Senate tries the case.
Exactly. It requires specific votes, follows its own rules. It's about fitness for office, not imposing criminal punishment in the judicial sense. So no, impeachment is not considered a bill of attainder.
Okay, important distinction. And like most ConLaw topics, there's debate among scholars.
Oh, always. Some argue the doctrine is a bit vague, or that courts are sometimes reluctant to actually strike down laws as bills of attainder.
Why reluctant?
Maybe deference to the legislature or difficulty applying the test cleanly. There's also debate about how broad that punishment prong should be. Does it cover any disadvantage imposed by law, or only things that look like traditional punishment?
Functional versus formalist approaches, right?
Exactly. And you also see differences based on interpretive philosophy. Originalists might look strictly at what the framers considered punishment, while living constitutionalists might adapt the definition to modern government actions.
So it's a complex area, but the core value seems clear.
Definitely. The ban on bills of attainder protects really fundamental things. Individual liberty from arbitrary government punishment, the separation of powers, and the basic idea of the rule of law that guilt is determined by courts, not by politicians.
Okay, I think we've covered the doctrine pretty well. Ready to test our understanding?
Let's do it. Bar exam practice time. We've got 5 multiple choice questions based on Angela's notes.
All right, listeners, pay attention. Question 1. A state legislature passes a law, the Public Safety Enhancement Act. It declares 3 specific people, John, Jane, and Jim, enemies of the state, for alleged cyber attacks. The law mandates seizing their assets and banning them from all employment, public or private. No trial occurred. Is this law constitutional? A, yes, legislative will reflects the people. B, yes, it's for public safety. C, no, it's a bill of attainder. D, no, it likely violates the ex post facto clause.
What do you think?
Yeah.
The answer is C.
Why C?
It hits all 3 Lovett prongs perfectly. It specifies John, Jane, and Jim. It inflicts punishment, seizing assets, banning work, and it does it without a judicial trial. Classic bill of attainder. D is less likely the primary issue. The targeting is the main problem.
Makes sense. Question 2. Back in 1542, Henry VIII in Parliament decreed a noble a traitor, seized his lands, and executed him. This historical practice directly influenced the framers to include which constitutional prohibition? A, ex post facto clause. B, ban on cruel and unusual punishment. C, bill of attainder clause. D, suspension clause, habeas corpus.
Thinking historically, the answer is C.
Explain.
That kind of targeted legislative punishment by Parliament, like Henry VIII did, is exactly what the framers were reacting against when they wrote the Bill of Attainder Clause. It's the textbook historical example.
Got it. Question 3. Congress passes a law banning federal student aid for 5 years to anyone who publicly supported a specific terrorist group. The law names 10 individuals, stating the ban applies to them based on past affiliations. No court needed. Which Lovett prong is most clearly met by naming the individuals? A, punishment. B, specification of the affected persons. C, without a judicial trial. D, serves a compelling government interest, not a prong of the test.
Focus on the naming part. The answer is B.
Because it literally names them.
Exactly. While denial of aid is likely punishment, A, and there's no trial. C, the act of naming those 10 people directly satisfies the specification requirement. It singles them out.
Clear enough. Question 4. A state passes a law in 2024 saying anyone who drove a red car on Main Street in 2023 is guilty of reckless endangerment and fined $1,000. What's the most likely constitutional problem? A, bill of attainder. B, ex post facto law. C, privileges and immunities violation. D, infringement on right to travel.
Think about the timing. The answer is B.
Why ex post facto?
Because it's making conduct from the past, driving a red car in 2023, criminal and imposing a penalty after the fact. It's retroactive criminalization. While maybe you could argue attainder if the class is tiny, the clearest issue is ex post facto.
Okay. Last one. Question 5. The House impeaches a federal judge. The Senate convicts and removes the judge. This process is generally considered A, an unconstitutional bill of attainder. B, an unconstitutional ex post facto law. C, a permissible political process distinct from a bill of attainder. D, a violation of the judge's Fifth Amendment due process rights.
We talked about this distinction. The answer is C.
Because impeachment isn't a criminal punishment.
Right. It's a political remedy, removal from office, following specific constitutional procedures. It's separate from the judicial process and not considered a bill of attainder.
Excellent. Now let's try applying this to an ME-style essay. Ready for this scenario?
Lay it on me.
Scenario. Harmonyville is fed up with the Free Spirit commune causing disturbances. The town council passes the Harmonyville Public Order Act of 2024. Section 1 says, all members of the Free Spirit commune are declared a public nuisance and forbidden from living in Harmonyville for 5 years. Any property they own here is forfeited to the town. Council members said, we know who they are, we don't need a judge. No hearings were held. Commune members challenged the ordinance.
Discuss whether this ordinance is an unconstitutional bill of attainder.
Okay, classic MEE setup. Let's IRAC it.
What's the issue?
The issue is whether the Harmonyville Public Order Act violates the Bill of Attainder Clause of Article 1, Section 10, which applies to states and, by extension, municipalities like Harmonyville.
And the rule?
The rule is Article 1, Section 10 prohibits states from passing bills of attainder. A bill of attainder is a legislative act inflicting punishment on named individuals or an easily ascertainable group without a judicial trial. We use the three-pronged Lovett test. 1. Specification of affected persons. 2. Infliction of punishment. And 3. Absence of a judicial trial. This upholds separation of powers and individual liberty.
All right, let's do the analysis. Apply the facts. Prom 1. Specification.
Yes, clearly met. The ordinance targets all members of the Free Spirit commune. Even if loosely organized, they're identified as a specific group, and the council members even said, we know who these people are. It's an ascertainable group.
Prong 2. Punishment.
Definitely. Being banned from living in town for 5 years, that's punishment banishment, essentially. And immediate forfeiture of property, absolutely punitive.
Okay. Prong 3. Without a judicial trial.
Also clearly met. The council explicitly bypassed the courts. We don't need a judge. No hearings, no individual determination of guilt for the disturbances. The legislature just declared them guilty and imposed the punishment. That's the definition of lacking a judicial trial.
And what about separation of powers?
Big violation here. The town council, legislative, acted as judge and jury, usurping the judicial function. It's exactly what the Bill of Attainder Clause aims to prevent.
So, the conclusion?
The Harmonyville Public Order Act is pretty clearly an unconstitutional bill of attainder. It meets all three Lovett prongs and violates the separation of powers. It should be struck down.
Excellent walkthrough. Hopefully that IRAC breakdown helps you see how to structure an answer on the exam.
Yeah, that covers bills of attainder quite thoroughly, I think. We really hope digging into Angela's notes like this has been useful for your studying.
And a big thank you, as always, to Angela for the notes and to Carol for helping her put them together.
Definitely. Now, just a couple of quick reminders before we go.
Right. First off, Angela's a law student, like you. Not an expert yet, hasn't passed the bar herself.
And neither she nor the podcast is giving legal advice. We're an AI study aid, not a replacement for hitting the books or, actual legal counsel.
Think of us as a supplement, definitely not your only study method.
And hey, we're AI. We sometimes make mistakes. Angela tries to catch them. Her notes are great, but errors can happen. We do our best to be accurate.
Also, this whole podcast series is just an academic project by Angela, non-commercial, purely for education.
And last but not least, if you are studying for the bar in your car, please drive safely.
Yeah, seriously. Don't cause a tort while listening to constitutional law.
Oh, good one. And remember, if you are an attorney needing freelance help with research, motions, or legal AI setup.
Angela's email is hello@legalwriterandlawclerk.com.
All right, I think it's time.
Tradition dictates. You got the joke.
I do. Why did the Constitution break up with the legislative branch?
Why?
Because it kept trying to get attainder.
Oh, wow. Okay, that's definitely cheesy.
Mission accomplished.
This is Claude and Maude, your AI hosts, signing off.
We'll see you on the next podcast. Thanks for listening. Bye.
Attainder. LOL. Yeah.